Good morning or good afternoon. Hello to everyone. Thank you for attending our webinar today, Election Day Impacts for Cyber and Privacy. Before we begin, there's a few housekeeping items we have to cover. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try and answer the questions during the webcast, but if there's a fuller answer that's needed or if we run out of time, we'll answer them later by email. A copy of the slides from today's presentation are available in the resource widget, and you can find additional answers to some common technical issues in the help widget that's at the bottom of your screen. Today's webinar is CLE accredited in California and Illinois for 1.0 hours of general CLE credit, in Missouri for 1.2 hours of general CLE credit, and in Texas for 1.0 general credit hours, which is pending. We have to award CLE based on attendance for the entire 60 minutes, so stay tuned. From time to time, you'll be required to click a pop-up screen to reflect your continued engagement on the webinar. Your CLE certificate will be emailed to you later this afternoon once we've verified your attendance. The widget at the bottom of the screen saying certificate will only show whether or not you have earned the certificate. We value your opinions and appreciate your participation today. So what are we going to talk about today? So we have a great panel and an interesting topic. Privacy and cyber are very interesting. Elections are interesting, particularly last week's one. And you put them together and we have a really good topic. And so our panelists here today, I'd ask them to introduce themselves, and then after that, we'll get started. Ken.
Hi, thank you. Thanks, Jim. I'm Ken Salomon. I'm a partner in the Washington, D.C. office of Thompson & Coburn. I founded our lobbying and policy group and about 8 years ago, and I've been doing lobbying in Washington for decades, and I'm delighted to participate today.
Thank you, Ken. I'm Luke Sosnicki. I'm a litigator in Thompson Coburn's Los Angeles office. My background is primarily financial services litigation. I've been advising banks and mortgage companies and other financial services companies for quite a while. Also have an active data security and privacy practice, advising not just financial institutions, but all sorts of companies on those issues, and particularly with respect to litigation and enforcement risks. Libby?
Good afternoon. My name is Libby Casale, and I'm an associate in the Business Litigation Practice Group, and I am in the St. Louis office of Thompson Coburn. And I'll turn it back to Jim.
Thank you. Thank you. I'm Jim Shreve. I'm a partner with Thompson Coburn and chair of the cybersecurity practice. I've been advising on cybersecurity issues for over 20 years now, and I'm resident in both the Chicago and DC offices of the firm. So what are we going to talk about? Well, we'll start off with Ken. We'll give some really helpful insights on sort of the broader general issues out of the election results from last week. Then we'll turn to talk about the California Privacy Rights Act, which was on the ballot in California. We'll let you know how it came out. Keep you hanging on there to hear how what happened. We'll talk about some of the litigation aspects to the election. Look at the congressional elections and legislative prospects for privacy and cybersecurity related legislation in this new Congress. We'll talk a little bit about how the elections may impact federal agencies, those who are enforcement agencies or regulatory agencies, and as well as a few other election related issues that may impact privacy and cyber compliance. And then we'll close with a couple of parting thoughts and any questions we haven't addressed to that point. But as I said, certainly feel free to submit questions right along, and we'll try and get to those if we're able to. So with that, I'll pass it off to Ken.
Thanks again, Jim. So what do we know at this point from the election? Biden is the president-elect, but his margins were narrow in several of the swing states. Trump has not accepted the outcome. His lawsuits and recounts will drag on possibly for weeks, but I will say that historically very few recounts overturn initial election results, particularly where margins are in 10 to 20,000 vote range. Trump yesterday formed a fundraising super PAC. So even in defeat, he may roil and keep control of the Republican Party, especially if he or one of his children say they will run in 2024 for president. Control of the new Senate is in limbo until January 5th, with the outcome of Georgia's 2 Senate runoff races. A concern for the GOP right now is whether Trump holds fundraising rallies across the country for his legal strategy and new super PAC, which could draw away campaign contributions from the 2 Georgia GOP Senate candidates. With the North Carolina and Alaska Senate races being the other 2 not called, right now it's a 48-48 Republican-Democratic tie in the Senate. If Alaska and North Carolina go GOP, Dems would need to win both of the January 5 Georgia runoff elections to control the Senate through Vice President Harris's deciding vote. It would be 50-50 at that point, with her casting the 51st vote. Democrats retain control in the House, although with a smaller margin. There are about 20 undecided races as of this morning, but it looks like the Democrats will have, at the end of the day, between 225 and 227 seats in the new Congress to the GOP's 208 to 210 seats. In real terms, what's the impact of the House and Senate election results moving forward to 2021? I have four conclusions. First, I think congressional moderates will play a pivotal role in a closely divided Senate and a narrow Democratic House majority. Second, President Biden will have to pursue a less progressive legislative agenda than he might otherwise have after first figuring out what sorts of policies a divided public, a sharply divided public, and a divided Democratic Party will support. Like Trump, I expect he will use a flurry of executive orders, especially early in his term, to reverse as many of Trump's policies that he can legally do through executive orders. Third, House Speaker Pelosi, weakened by a smaller majority that is aggravated by a growing rift between Democratic progressives and moderates, faces narrowed policy maneuvering room in the House. And fourth, current House and Senate GOP and Democratic leadership will continue in the new Congress. In fact, this afternoon, or earlier today at least, both the Senate leadership team and the Democratic leadership team in this were reelected. Of course, I make all these prognostications and say all this with the same level of certainty and accuracy as the pre-election polls, so take it for what it's worth. In Congress, the key committees with privacy and cybersecurity jurisdiction. In the House, it's the Judiciary, Financial Services, and Energy and Commerce committees, and I don't expect any Democratic leadership changes there. Chairman Nadler will continue at Judiciary, Chairwoman Waters at Financial Services, and Frank Pallone will continue on Energy and Commerce. On Judiciary, there are 4 vacancies, 1 Democrat and 3 Republicans, including the Republican ranking member who will be replaced by Jim Jordan of Ohio in the new Congress. Chairman Nadler's top issues are reining in big tech and enhancing consumer data privacy. The other thing he's really focused on for the last 2 years has been updating the antitrust laws to better deal with the power and growth of big tech. Financial Services Committee has 3 or 4 vacancies with the defeats of 1 or 2 Democrats and 2 Republicans. The ranking GOP member is likely to stay Congressman McHenry, but he could move up in the GOP leadership, which would mean he'd have to give up his committee leadership position, and there'd be a new senior committee Republican. Chairwoman Waters' immediate focus is expected to be on the housing and economic crises, but consumer data privacy and cybersecurity are important issues both to her and to ranking member McHenry. Energy and Commerce Committee has 9 vacancies, the most vacancies, 4 Democrats and 5 Republicans. Pallone is reported to be, Chairman Pallone, drafting a climate change bill to go with right out of the gate, but he's also focused on strengthening the Affordable Care Act. The Supreme Court heard oral arguments on that this morning, and consumer data privacy. A new ranking GOP member will be named a senior Republican because the current member retired. I will point out that the chair and ranking Republican on the Energy and Commerce Consumer Protection Subcommittee both are supporters of federal data privacy legislation. The Senate committees with key jurisdiction are Judiciary, Banking, and Commerce. Assuming continued GOP control, Senator Grassley will replace Senator Graham as chair of the Judiciary Committee for the next 2 years. He chaired it for 4 years and has 2 years left. The GOP chairs and ranking members are limited to 6-year terms. Grassley believes it's past time for a uniform national data security and breach notification bill. The ranking Democrat is Senator Feinstein, who's also the oldest member of the Senate, and there's some grumblings within the Democratic caucus that it's time for her to put down the mantle as ranking member, and the leading candidates, if there is a push to replace her, are Senators Whitehouse or Klobuchar. And Klobuchar, as you may recall, ran for the Democratic presidential nomination. If Feinstein stays, it's important to note that she will not support a bill, she has said, that would weaken the California privacy legislation. Senator Harris becoming vice president creates 1 Democratic vacancy on the committee, but there could also be an open GOP seat if Senator Tillis is not reelected in North Carolina. We may know the results of that race by the end of the week. On the Banking Committee, Senator Toomey will replace Senator Crapo as chair, and Senator Brown will continue as the senior Democrat. There are 2 and as many as 4 vacancies on banking. Democrat Doug Jones and Republican Martha McSally were defeated, and Tillis is also on banking, as is Senator Perdue from Georgia. So if Tillis and or Perdue loses in Perdue in the Georgia runoff, it would mean 2 GOP vacancies. The major issues of focus for both Toomey and Brown are housing, but both are concerned about consumer data breaches. Historically, with Brown, the more aggressive of the 2, the Democrat, wanting to hold corporations, big tech, and government accountable for failure to protect consumers harmed by data breaches. In the Commerce Committee, Chairman Wicker and Ranking Democrat Cantwell stay in charge. There's one Republican and one Democratic vacancy, one to replace defeated Senator Gardner, a Republican, and the other retiring Senator Udall. Both Wicker and Cantwell support national data privacy legislation, each introduced separate bills in the current Congress, with the most significant difference between them being Wicker's support and Cantwell's opposition to state consumer privacy law preemption. It's also worth noting that Senator Portman will assume the chairmanship of the Homeland Security and Government Affairs Committee, where he's expected to shift the focus from investigations of the Bidens to cybersecurity, particularly government cybersecurity. In sum, on data privacy, while there has long been bipartisan congressional outrage over large data breaches, followed by lots of hearings and bills introduced in both the House and the Senate in successive Congresses, Republicans and Democrats' inability to bridge the gaps in approach, scope, and details have prevented final legislative action. It's hard at this point, given the pretty long shot of Democrats winning both Georgia runoffs, giving them narrow Senate control next year, to envision a privacy bill being sent to President Biden, particularly one that preempts states, and particularly California's consumer privacy laws. On cybersecurity and online liability protection, the unhappiness with big tech in this Congress in particular is bipartisan, and in the House and the Senate. A Biden administration likely will continue Trump Justice Department's pending antitrust suit against Google, but likely with less ferocity. Where things are more likely to be bipartisan in the new Congress will be legislation limiting big tech and social media Section 230 liability protection. So that's what I have to say. I'm happy to take questions at the proper time, but Jim, back to you.
No, thank you, Ken. If anyone has a question for Ken on all the great information he gave there, please go ahead and submit it in the Q&A widget at the bottom of the screen. But if not, we'll move ahead to states, particularly California. There was a big, California's been at the forefront of privacy for many years, and the California Consumer Privacy Act was the most significant privacy legislation at the state level, probably ever. California was considering changing, augmenting CCPA with the CPRA. And so with that, I would turn it over to my colleague Luke Sosnicki to tell us a little more about CPRA.
Thank you, Jim. All right, so a lot of the folks on this call who just went through some variation of trying to implement the CCPA are probably wondering why California seems to be in rapid fire mode with respect to privacy legislation. And I think one of the answers to that is the ballot initiative process. So California has a process that allows California citizens to gather signatures for proposals. If you get enough signatures, get it certified, you can put your ideas on the ballot. And that's actually how the two key privacy statutes in the state came about. So the CCPA dates back to late 2017, the initiative itself to 2018, sponsored by an organization chaired by a gentleman named Alistair McTaggart. The CCPA, again, arose as a ballot initiative in the summer of 2018. It was actually taken over by the legislature, and there's a little bit of a backstory to that. The short version is that McTaggart agreed with the state legislature that if the legislature passed in substantially similar form the bill that he proposed to be on the ballot and the bill that had gathered enough signatures by that point to appear on the ballot, then he would withdraw his proposal and allow the legislature to shepherd that process, which is exactly what happened. So the legislature did take over the process, passed the bill in a very, very short time. And as a result, as has been widely reported, the bill had some issues that needed to be fixed with numerous amendments. The bill also went into a regulation drafting process that lasted for a bit. The final regulations just came out earlier this year and actually are still being amended. The last amendments to the regulations came out within the last 45 days. The new statute, the CPRA, followed much the same process and with much the same people. The same organization that came up with the CCPA came up with the CPRA, which, as you will hear a little bit later today, amends the CCPA and strengthens it in some respects. This time, however, although there was speculation that the same thing might happen again with the legislature, it didn't. So the version of the statute or the version of the bill that was presented to California voters just last week is the version that that is going to go into effect. So Libby, can you tell everyone what's in this new statute that makes it different than the existing CCPA?
Sure. So right off the bat, one difference is that the CPRA provides for the creation of the California Privacy Protection Agency. So this is a new agency that would share responsibilities for overseeing and enforcing state consumer privacy laws along with the California Department of Justice. Additionally, the CPRA differs from CCPA in that the definition of business is modified. So one aspect of the definition that's modified is that it increases the threshold from 50,000 to 100,000 or more consumers or households, and also removes devices from that part of the definition. Additionally, it adds to the definition of business that the annual revenues are derived from selling or sharing consumers' personal information, with sharing being a new aspect of that definition. And additionally, it clarifies that the calculation of annual gross revenues will be as of January 1st of the calendar year, calculated based on the preceding calendar year. Additionally, CPRA revises some of the exemptions relating to business and employee data. And also a big distinction is that it provides for, the CPRA provides for sensitive personal information as a new category of personal information. And the CPRA does give consumers the right to limit the use and disclosure of that sensitive personal information. And additionally, the definition of publicly available information was also revised. So now this covers information that a business has a reasonable basis to believe is lawfully made available to the general public by the consumer or from the widely distributed media, and also information that's made available by a person to whom the consumer has disclosed the information if the consumer has not restricted the information to a specific audience. So those are a few of the kind of major distinctions between CPRA and CCPA. So kind of turning next to election results. Based on a review of the California Secretary of State's website this morning, the margin that Proposition 24, which is the California Privacy Rights Act, so that margin that it passed by was about 56% of the vote, as opposed to, which comes to about 8 million, and about 6 million were against that. So the results of the election will be certified by December 11th, 2020. The substantive provisions become effective on January 1st, 2023, with new regulations expected to be introduced by July 1st, 2022. The California Privacy Rights Act also provides that beginning the later of July 1st, 2021, or 6 months after the agency provides notice to the Attorney General, then the authority assigned to the Attorney General to adopt the regulations will be exercised by the California Privacy Protection Agency. And additionally, initial appointments to the agency shall be made within 90 days of the effective date of the act. So that's kind of the timeline for the CPRA to take effect. And now I'll turn it back to Luke.
Thank you, Libby. So the big question remains, so the CCPA is amended. What does that mean as a practical matter for folks who've spent the better part of 2 years amending their processes and their policies to comply with the CCPA. So it's not, as Libby just said, it's not a complete overhaul of the CCPA. The key provisions regarding notices to consumers, regarding businesses' obligations, as well as litigation risks, are largely the same with certain tweaks. The new agencies is certainly a big change, but in terms of companies' response, again, kind of the underpinning, the key tenets of the statute are the same. That said, there is going to be a compliance burden, including because the regulations are going to need to be updated and amended. Again, the Attorney General spent a lot of time and a lot of effort coming up with regulations to implement the CCPA. There were public hearings, there were a number of public hearings, there were a number of comment periods, and again, the process just wound up earlier this summer with additional regulations coming out even more recently than that. And while it's not going to require a back to the drawing board process, they are going to need to be amended, and when the regulations, the implementing regulations are amended, companies are going to have to inform themselves of the amended regulations and comply. As Libby mentioned, the new category of sensitive personal information that the CPRA creates is going to be of particular importance. When companies are doing data inventories, when companies are trying to figure out exactly what information they're collecting, how they're storing it, and what they're doing with it, they are now going to have to make a determination at the outset of what information they're holding is subject to this new category of sensitive information, as opposed to the more broad, all-enveloping category of personal information that the CCPA provided. So again, it is going to require it's going to require some work, and as Libby mentioned, the statute doesn't take effect for a few years, so there is going to be some lead-up time. But again, it's going to be some work. So, Jim, what do you see as some of the impacts of this new legislation, the CPRA, beyond California?
Thanks, Luke. I think to assess the effects of CPRA outside California, need to consider a few issues within California. One is that looking at this legislation, typically privacy initiatives on the ballot, and in the very limited history we have with them, have proven pretty popular. It's generally not hard to convince people to vote for more privacy. If you say, do you want more privacy or less privacy? Most people, not surprisingly, say more. And there was a ballot initiative in North Dakota about 15 years ago that passed by about 80 to 20. CPRA in the lead up to the election appeared that it was going to pass somewhere in the mid to upper 70s range, but ultimately ended up around 56%. And I think this is important for some of the reasons why it may have fallen down. And I think some of that has to do with a bit of a splintering of support among some of the privacy advocates. You had a few groups who you would expect to support something like this in California, but didn't. The Northern California branch of the ACLU came out against CPRA, saying that the loopholes that they allege were created outweighed the benefits of it. Some other privacy groups didn't take a stand on it. They remained neutral on CPRA. And so as a result, I think that's why you saw a narrower passage amount than I think most people thought you would see. I also think it's important to consider the role of ballot initiatives in California. CCPA was driven mostly by it being the threat of a ballot initiative. CPRA passed through the ballot initiative. Most states don't have something like that. And legislation in this area has been difficult to pass, in part because, honestly, lobbying has been fairly effective at the state legislative level on privacy. We've seen bills that have passed unanimously in one house of the legislature and then suddenly die in the other house. I think Washington State is an important one to consider. They are taking up in this next year the third version of the Washington Privacy Act, which would take certain aspects of both CCPA, CPRA, and the European Union's GDPR, with the right to limit sales, right of access, right to correction, deletion, portability. If there's going to be something that follows on the coattails of CPRA, that seems to be the most likely thing. But I think we will see some influence in other states from CCPA, CPRA. First, it could be a template for legislation in other states. Something I think quite well could pass in a state legislature. In fact, I think that's much more likely than something passing in the federal legislature. And CCPA could be the template for that, much in the way that California's breach notice law was a template for the breach notice laws that have now been passed in all other states. I think CCPA and CPRA could also have effects beyond California from companies simply deciding to extend California rights beyond California residents. And we've certainly seen this. Just as we had under GDPR, some companies are deciding we're going to apply these rights globally. And so if we have someone who's a non-resident of California that wants to obtain further information about what information we have on them, we're going to honor that request. And so we may see some companies, probably mostly larger ones, that are giving CCPA rights outside of California. We also might have CCPA and CPRA changing the expectation for what is reasonable. You know, state AGs can bring actions under UDAP statutes or other consumer protection statutes for conduct that's unreasonable in some way. And CCPA and CPRA could be changing the concept of what is reasonable in privacy and have impacts beyond California. I think another thing to think about with California is with respect to the GDPR. There's been some talk in the last few months that because the European Union can deem not just nation-state jurisdictions to be adequate, but they can do that under subparts of nation-states. And there's been some talk that possibly California, but not the rest of the United States, could be deemed adequate under GDPR. I mean, I think we can certainly see many aspects in CCPA and CPRA that are patterned after GDPR. You know, the deletion rights, the data minimization, right to be informed, right to limit sharing, look a lot like GDPR, and that's intentional. Certainly, Alistair McTaggart intended a lot of that. Also, CPRA creates a specific privacy regulator and enforcement agency, which has long been a criticism by the Europeans of the American system, that there's not a common regulator for everyone in the area of privacy. And so it does create the possibility that somewhere down the road, and I wouldn't think until after CPRA is effective, California potentially could be deemed to be an adequate jurisdiction. So with that, let's move on to federal elections. We had many. It looks like we, according to what Ken said and certainly what I've been reading, we're most likely going to have a split Congress, with the Democrats having a narrower majority in the House and probably in the minority still in the Senate. But let's talk a little bit about some of the noteworthy results. And I think to go into that, let's maybe turn to Libby Casale, talk a little bit about maybe some of the privacy legislation that we've seen in the current Congress and prior Congresses, and consider how that may give us an idea where we may go going forward. Libby.
Thanks, Jim. So some of the recent proposals have included the Online Privacy Act of 2019, the Consumer Data Privacy and Security Act of 2020, Consumer Online Privacy Rights Act, the Data Protection Act of 2020, as well as a draft privacy bill from the House Energy and Commerce Committee in December 2019, and a discussion draft of the United States Consumer Data Privacy Act of 2019, which is a draft circulated in November of 2019. So some of the similarities among these proposals and bills include that they create procedures to enforce requirements on recognizing individuals' rights to control their personal information. However, among those, the definitions of personal information or data or covered information do differ, but generally they include information that is linked or reasonably linked to an individual. Some of the proposals provide for additional protections for sensitive personal information. However, the breadth of the scope of each of these does vary in terms of who they would apply to. Each of the proposals does seem to differ on whether or not preemption of state privacy laws would take place, whether or not it would provide for a private right of action, and which federal agency would have the enforcement power behind these. So whether or not it would be the FTC, a new bureau within the FTC, or whether or not a new agency would be created. And looking in previous sessions of Congress in 2018, there was the Social Media Privacy Protection and Consumer Rights Act. But again, each of these does have some similarities, but a lot of the approaches do differ. So Jim, I'll turn it back to you.
Well, thanks, Libby. As Ken talked about, and I think you could hear in some of what Libby was saying as well, both privacy and security have interest on both sides of the aisle. I think there's interest in having stronger privacy protection, stronger protections around personal information being secured and how it's shared by both Republicans and Democrats. On Capitol Hill, I think there are two main areas. One is structural, and one is content related that have made it very difficult to pass some larger privacy or security legislation in Congress. Because after all, we've been really at this for a long time. I mean, that there's been talk of some great federal privacy or security bill, certainly ever since California enacted its breach notice requirements in 2003. But we really just haven't seen anything get through. And a great example of the issues here, and if those of you who've heard me speak before may have heard this story, but for several years there was legislation on creating a federal breach notice standard that was co-sponsored by Representative Cliff Stearns from Florida and Representative Bobby Rush from here in Chicago. Cliff Stearns was fairly conservative Republican, Bobby Rush, pretty liberal Democrat. These two didn't agree on much, but one area where they did agree, and to the extent where they could co-sponsor bills through multiple Congresses, was on data security. And so this bill was introduced in the House Commerce Committee in several Congresses, and when the Republicans were in power, it had Cliff Stearns' name first. When the Democrats were, it was Bobby Rush's name first. And it kept being brought forward, and it never got any farther than getting through the House Commerce Committee. And I think part of the problem is that there are so many committees that assert jurisdiction over privacy and security topics. Ken talked about the Commerce Committees on both sides of the Hill. You've got the Financial Services Committees on both sides of the Hill, and the Judiciary Committee. Getting a bill through all 6 of those committees is exceedingly difficult. And to this point, nothing has really even come close. And so I don't see that dynamic having changed significantly in the current election. So that's the structural issue. I think there's also a couple of issues that go to the substance of the bill. The biggest one certainly is preemption. Preemption of state laws is probably the prime reason that industry would like to have a federal law. That said, many Democrats will not preempt stronger state consumer protection laws, particularly with so many Californians in congressional leadership. And as well, you have a certain amount of states' rights Republicans. I think those are somewhat rarer now, but who, just as a matter of principle, don't like preempting state laws. And so, to me, I think it would take several incompatible, or at least inconsistent state laws, complying with all of which would create a significant burden to create sufficient pressure in Congress to really put in the lobbying effort to get a bill through. As noted before, I mean, there's reason to question if we'll see a lot of laws like CCPA just because it's difficult at the state level as well to pass legislation. But if we do have some more of those state laws, that would make a federal law, I think, more likely. Without preemption, I think industry, it's questionable whether industry will really push very hard for a federal law. What we may end up with is something that the compromise, if there is one there, might be something like creating a high floor, which would set federal privacy standards that are more stringent than some on the right may want, some more pro-business members of Congress may want, in order to obtain preemption of the state consumer protection laws. Private right of action is another big issue. And I think that as well, it seems unlikely to get through the Senate. My colleague Luke may have some more thoughts on that in discussing litigation prospects. I will say there is always a risk that a bill could be attached to some other bit of legislation that has to pass, an appropriations bill or something like that. And so suddenly we could wake up tomorrow and we have a federal privacy law or federal security law. That is always a possibility, something to keep an eye out for. But I think we may not know that's happening until very late in the process. I do think having a privacy provision in a bill that regulates technology makes a certain amount of sense, and we may see something like that as well. So if no further questions there, maybe we can move on to the executive branch, looking at how federal agencies may change after the election. And Luke and I are going to talk about a couple of agencies specifically. We both come from largely a financial services background, and so these are two that we've dealt with quite a bit. And I think they show very different effects of the Trump presidency on regulatory and enforcement agencies. The first one is CFPB, the Consumer Financial Protection Bureau, which was created under the Dodd-Frank Act, was championed by Elizabeth Warren, but has become, I'd say, almost despised by Republicans and who sought to curtail its funding and its oversight. And so what we've seen under the Obama administration is a significant curtailment of actions by the CFPB, both in regulatory and enforcement, from what happened under Obama. In fact, the Trump administration came in saying that they wanted to get rid of the CFPB entirely. But over the last 4 years, we've had the director of the CFPB criticizing the agency's even existence, and far fewer actions and hollowing out of CFPB staff. Luke, do you have any thoughts about what you've seen with the CFPB, either in the past or how that may go going forward?
Sure. Thank you, Jim. Yeah, I mean, I think it's fair to say that the CFPB has had kind of a tumultuous history during the Trump administration, with the appointment, including with the appointment of an interim director, Mick Mulvaney, who had been openly hostile to the agency itself. As Jim mentioned, funding significantly dropped. There was a mass exodus of CFPB employees around that time, and the enforcement activity also significantly dropped. When Kathy Kraninger was nominated and eventually took over a little bit later, she came in, I think, with similar expectations that rolling back regulations, easing up on the financial institutions. And initially, I mean, she came in with, when one of her first public comments, she stated that she was going to roll back regulation by enforcement. She was going to try to clarify the applicable regulations, clarify the playing field instead of pursuing enforcement and then clarifying after the fact why you were sued. And I think initially in her term, that was certainly her approach. I will say that recently, the CFPB's pace and enforcement actions has actually picked up, and in the third quarter of 2020, it's certainly exceeds anything under Mulvaney, and is actually back to Cordray levels. Now, query whether that in part is looking forward to the election, since the Supreme Court's decision this summer giving the president back the authority to replace the CFPB's director. Query whether the uptick in enforcement is based in part on the realization that a Biden administration might well replace the director. But then again, enforcement is picking back up. That said, I think the expectation remains that a Biden administration is going to be more active in the space. The CFPB is going to file more actions and make a comeback under a new Democratic administration.
Thanks, Luke. And then I think we can contrast this with what we've seen under the Trump administration in another agency with enforcement and regulatory authority in privacy and security for financial services, as well as somewhat beyond that, and that's the FTC. The FTC has enforcement authority over several areas of privacy and security, although some of that authority was given to the CFPB when it was stood up. I would say at the FTC, historically, staff have been given room to do their work by the leadership. They've brought several actions on privacy and security over several years. And I would note that for many years, nearly all of those enforcement actions where they've entered into consent orders, they've been unanimously approved by the commission or approved at worst by a 4-to-1 margin. Under the Trump administration, we had a complete turnover of the commission itself. And it was a change from 3 Democrats to 3 Republicans of the 5 members. And I would say the commissioners came from a more antitrust background than from consumer protection. But I would note that the FTC continued bringing actions during the Trump administration at close to that historical rate. Although I would note that many of those actions were approved 4-to-1 or 3-to-2, and interestingly, occasionally with the Republican chair joining the 2 Democrats. But overall, we've seen considerably less change at the FTC under the Trump administration than under the CFPB. Now, and so I was all prepared that would be my presentation. And thankfully, the FTC chimed in and gave us more to think about when they released a consent order yesterday involving Zoom. I think I would encourage everyone to take a look at the consent order about Zoom. There's some important points there, but make sure you read both the majority opinion, but also the two dissenting opinions, because I think that raises some issues potentially going forward. Similar to many consent orders of the past, Zoom was not assessed a monetary fine. They pledged to make an improvement in their processes going forward, and they're going to have regular outside review of the improvements. Now, if you look, though, at Commissioner Chopra, his dissent, I think that's particularly interesting because it takes issue with this normal FTC way of doing things in consent orders. It makes several specific requests going forward to consider bringing more actions into litigation and not settling them through a consent order, having more monetary fines, making actions more public and the factual allegations in the actions more public. And so as we switch over, presumably, and go to a 3-2 Democratic-led commission, it'd be worth watching to see if Commissioner Chopra stays on the commission, and if potentially he could be elevated to the chair position, which I think is possible. I do agree with Luke. I think that under the Biden administration, the CFPB will come back. I could see them potentially not being maybe as aggressive as before. And coming back may take a while because, as we noted, they've been fairly hollowed out. A lot of the staff have left over the course of the last 4 years or so, and so they're going to have to hire quite a few people to get going. I would note that we got a question about what may happen at HHS with regard to enforcing HIPAA privacy and security. And I mean, my perception of HHS is they're probably, if you have the two extremes of the CFPB and the FTC, HHS has been a little bit closer to the FTC, and I think there's been some curtailment of actions under the current administration. It hasn't been as severe as some of the changes we've seen at others like the CFPB or the FCC. So I think it would be reasonable to expect some increase. How much, I think it's harder to say, but I think that would be a reasonable expectation. So with that, let's talk a little bit more about litigation impacts out of Election Day. Luke.
Thank you, Jim. Well, let me start maybe with the federal side. As Jim, Ken, and Libby all said, the prospect for federal legislation isn't great. The prospect for a federal private right of action similarly isn't great. That doesn't mean that litigation relating to data security won't proceed under common law theories, but again, in terms of a federal statute conferring a private right of action might not happen. So I think the primary change to kind of the landscape of litigation is going to be on the state side. Certainly the CPRA is going to change litigation, and I'll skip to the punchline. I think litigation is going to increase. And I guess to explain that, it bears repeating how the current CCPA's private right of action works. So the current CCPA is privately actionable for data breaches. So it gives consumers a right to sue companies when the consumer's data is breached. The definition of the data that is subject to the right of action is different than the definition of personal information generally. So only a subset of personal information, when breached, confers on the plaintiff a private right to sue. And the CPRA expands that definition. So whereas the current definition includes such things as name in combination with a social security number or a credit card number, bank account number, the CPRA amends that to also include an email address in combination with a password or security question that allows access to the account. So that opens up a category of private lawsuits that just weren't available before. Second more significant impact of the CPRA on litigation is the creation of a specific agency to enforce it, and not just a specific agency, but a well-funded specific agency. So whereas the Attorney General's office was the primary enforcing body under the CCPA, there's going to be a separate agency to do that in the future. And I think that is going to be a fairly significant change. The Attorney General's enforcement activity only began in July. And through reports from the Attorney General's office, we know that they did send some letters of inquiry to companies, but there haven't been any actions yet. And I think, part of that is, budgetary. Well, part of that, I think, is just manpower issues that I think a separate agency tasked with that specifically would certainly address. The one, hope is that the CPRA also changed the definition of business to larger businesses. So whereas it was covered businesses before, businesses that collected 50,000 or more records, it's going to be 100,000, which at least for purposes of the the California legislation exempts certain smaller businesses. I still think, given the nature of the CCPA lawsuits that have come in and the allegations and the specific breach data that the lawsuits have dealt with so far, I still think the net result is going to be increased litigation just because of the broader scope. So with that, Jim.
Thanks, Luke. So consider a few other things from the election as well. Think about Joe Biden. Not really a significant history on privacy and security. It's not. He hasn't been supportive of efforts, but I would say it's not been among his primary issues. From what I've seen, which contrasts with Kamala Harris, who was California Attorney General and took on some privacy-related issues there. Luke, do you have any thoughts from California on Kamala Harris on privacy?
Yeah, and thank you, Jim. And I'll be brief. I know we're running short on time here. Kamala Harris actually has a pretty extensive record on data privacy issues in California, dating back to 2011 when she took over as the state Attorney General. One of the first things she did is shepherd an agreement between social media companies relating to privacy policies in apps. Also, within a few months of her taking office, started up a specific privacy enforcement and protection unit within the AG's office. Brought a number of cases, including against Comcast, Anthem. In a 2016 data breach report, so this is a report issued out of the AG's office, kind of chronicling the status of reported data breaches in the state. She offered her thoughts on, or at least the AG's office's thoughts on reasonable security, implementing mostly the SIS-20 controls. And that's still cited today as potentially kind of the foundation for what reasonable security might mean for purposes of the CCPA's and now CPRA's private right of action. So she has a good amount of knowledge on this that transferred into the Senate as well. She had a prominent role in the 2018 Senate hearings regarding the Cambridge Analytica scandal. Some of you may have seen her grilling of Mr. Zuckerberg. So she has a good foundation. And more importantly, she has a very good understanding. She understands the issues, and I think we can all expect that a renewed focus on some of these just based on her election. Jim?
Thanks, Luke. Just to kind of close up with other effects. States, we talked a little bit about state legislative process and how something could happen there, although it faces some headwinds. But also, I think something to watch is state AGs. State AGs pretty much all have this ability to bring consumer protection actions under some sort of general consumer protection law or under their general UDAP authority. And this is something that I think certainly we could see happening in the absence of legislation is, given that state AGs could begin to bring more actions both in California or even in states that don't have a comprehensive privacy or security law in place. Again, I'd like to thank everyone for attending. This webinar is part of a series that our cybersecurity team is doing at least every month. Well, we're not going to have a December one, but we'll start up again in January, and we'll have monthly webinars into 2021. We'll take your suggestions. If you have content that you'd like to hear about, let us know, and we'll try and cover it. We also have a lot of written content up on our website. We have a group blog, newsletter, and you can go on there and sign up to receive those when we put those out. Then I would thank all of you for coming today. Thank all of our speakers for making for a great discussion today. Please complete and submit the survey that's in the widget at the bottom of your screen. And I thank you very much for coming here today and hearing about the election effects on privacy and security. Thanks.